Hello everyone, my name is Rachita Mathur, currently working as a legal intern at LEXCLIQ. So today I'll be dealing with the topic Dacoity, which is provided under section 391 of IPC. Now first of all, we will be looking at the essential ingredients of this section. First is that there should be at least 5 or more than 5 persons. Second, they should have conjointly commit or attempt to commit a dacoity, and the last is they should have a dishonest intention. Now further, while looking at the punishment for dacoity, we can say that punishment for dacoity has been provided under section 395 of IPC, as a person who commits a dacoity shall be punished with imprisonment for life or with rigorous imprisonment for a term which can be extended up to 10 years and shall also be liable to pay the fine. Further, this offence is cognizable, non-bailable and non-compoundable in nature. Now, while looking further, we can say that under section 396 of IPC, an aggravated form of dacoity has been defined with murder, and it states that if anyone of 5 or more than 5 persons who are conjointly committing a dacoity commits murder, in so committing a dacoity, every one of those persons shall be punished with death and shall also be liable to pay the fine. Further, there was one case of Lalia versus State of Rajasthan, where the court has observed that whether the murder is a part of dacoity or not, it totally depends on the circumstances of that time. The court has decided that the attention has to be put on the following points, and the first is whether the dacoit retreated or not. The murder was committed while retreating or not. Second is, what is the time interval between the attempt of murder and dacoity? Last is, what is the distance between the places where the attempt to murder and where the attempt to dacoity was being committed? Now, while looking further, there was another case of Sham Behri versus State of UP. In this case, the dacoit killed one of the victims who had caught the robber associated in an attempt to commit a dacoit. The robber was being convicted under section 396 of IPC because any murder which has been committed by the dacoits during their fight would be treated as a murder. Now, while looking further, the offences which are connected with dacoity, now in this case, for every criminal offence, there should be a mens rea on the part of the offender. In other words, we can say that there has to be an intention to commit a crime. And the word intention has not been explicitly defined under IPC, but under IPC section 34 of the code talks about the common intention. It further states that act which has been done by the several person in furtherance of the common intention. This section says that when a criminal act is being done by the several persons in furtherance of the common intention of all, every such person is liable for the act in the same manner as if it were being done by the person alone. Further, while looking further, we can say that as per section 402 of IPC, which states that whoever at any time after passing of this act shall be one of the 5 or more persons assembled for the purpose of committing a dacoity shall be punished with rigorous imprisonment for a term which may be extended up to 7 years and shall also be liable to pay the fine. Further, as per section 400 of IPC, we can say that anybody who at any time after passing of this act shall belong to a gang of persons associated for the purpose of habitually committing dacoity will be punished with imprisonment for life or with rigorous imprisonment for a term which may be extended up to 10 years and shall also be liable to pay the fine. Further, in the case of Arjun Ganpat Sandhbor versus State of Maharashtra, in this case, a truck driver was being killed and the driver was taken away by the dacoits. This incident took place in the darkness, so the evidence of the son of the deceased who was in the truck at the time when the incident took place were not free from doubt. He admitted that the time he used to have forgetting tendency, so the test identification party was not held according to the guidelines prescribed under criminal manual. So in the view of totality of the evidence, the accused was being entitled to acquittal. That's all for the day. Thank you.